I'm your host, Lauren Hope, and I'm the Executive Director here at the Second Service Foundation. It is our pleasure to introduce to you Mr. Alan Granwell, an attorney with Holland & Knight's Washington, D.C. office with more than 50 years of experience in international taxation. In his long and wide-ranging career, Mr. Granwell has represented multinational corporations and a globally oriented high-net-worth clients in a broad array of international tax planning, compliance, controversy matters, including serving as an expert witness. Mr. Granwell is humble. He might casually say that he was a former high-level Treasury official. On his behalf, though, I won't be so humble. The full scope. In the early 1980s, Mr. Granwell was the International Tax Counsel and Director at the Office of International Tax Affairs of the U.S. Department of Treasury. In that capacity, Mr. Granwell was the Senior International Tax Advisor at the Treasury Department, and he was responsible for advising the Assistant Secretary for Tax Policy on legislation, regulatory, and administrative matters involving international taxation and directing the U.S. tax treaty program. Mr. Granwell is a veteran of the Korean War. In today's lesson with the Master, Mr. Granwell is joining us to discuss the Corporate Transparency Act. Join me in welcoming Mr. Alan Granwell.
This act, which came into effect in on January 1st, 2024, will be important for you to know about if you are doing business through a certain type of entity, which I will describe, because if you fall within the scope of this act, there are certain reporting obligations which you need to know about and comply. So let me step back and give you a little background. The Corporate Transparency Act was enacted by Congress to forestall criminals and bad actors from utilizing LLCs, limited liability companies, and similar entities to conduct illicit activities in the United States, such as money laundering, terrorist financing, and other types of criminal activity. And the United States was late to the game because numerous foreign countries around the world had what is called beneficial owner provisions, whereby the owners of certain types of entities were required to inform the government through a report of their ownership in the entity. And the United States didn't have that, and commencing in around 2016, the United States was found to be the prime choice for individuals to use various U.S.-type entities, such as LLCs and corporations, to conduct those various types of illicit activities. So in 2021, after numerous efforts and undertakings, the U.S. Congress enacted what is called the Corporate Transparency Act. Okay. And that act kicked in on January 1st, 2024. And the purpose of the act is to require the reporting by individuals by reporting companies of their ultimate owner individuals. So this act is the first ever federal legislation to be enacted by the United States relating to beneficial owners, and it applies to the United States, which is defined very broadly to include the states, the continental United States, District of Columbia, but also the territories and possessions and commonwealths of the United States around the world. So places such as the U.S. Virgin Islands, Puerto Rico, the Northern Marianas, and other of our remote sort of territories or possessions are covered by this. And the way this works is that you first have to determine whether the entity is within scope of the legislation or not within scope. And we're going to go through all of this. And I just want to make the preliminary point here that the legislation was intended to ferret out illicit actors who are using these types of entities. But there will be a real burden imposed on legitimate businesses such as yours, because you will have to comply with this act if you are within scope. And if you have you conduct your business through a limited liability company or U.S. corporation where you're the sole owner, the reporting isn't all that onerous. But if you have a multi-tier structure involving trusts or other things, then there will be sort of some determinations that may be difficult to make. Okay. And so we will review all of this briefly so you get a feeling about what this is about, and then you can consider what your next steps are. So in terms of who reports, we first have to identify whether the entity that you may have is what we call a reporting company. And a reporting company can be of two flavors. It can be a domestic reporting company. It can be a foreign reporting company. A domestic reporting company is an entity which is formed through the filing of a piece of paper with the Secretary of State or similar agency. So if you form, for example, a limited liability company, which many of you may use to conduct your business because it has tax advantages and liability protection, that type of an entity to be formed requires the filing of a piece of paper with the Secretary of State of your particular state. A reporting company also includes what we call a foreign reporting company, and this might not be that applicable to your situation, but it is covered. And what we mean here is a entity which is formed outside of the United States, so it is foreign. Say it's formed in France or the UK or Germany or Hong Kong or places like that, and it registers to do business in the United States. And here, let me just explain what I mean by that. If, for example, you have a foreign entity, and many non-U.S. persons will use foreign entities to do certain things in the United States, and the entity does not register to do business in a state, then it is not covered. And why would a company register to do business? Because, in fact, it is conducting commercial activity and the state requires registration. So unless the company is registered to do business in the United States, an entity formed outside the United States is not covered by this reporting. Now, in terms of evaluating whether you are a reporting company or not, I also need to mention that certain types of entities are without scope or not in scope. And there are 5 types of entities not in scope. So if you have utilized a sole proprietorship where you're just doing business in your own name, an unincorporated association, a general partnership, and that's different than a limited partnership or its variants, where under a general partnership you have liability if you're one of the partners, or you form a common law trust for succession planning. Those types of entities are not within scope, and you don't have to comply with anything under this legislation. And then the 5th exception is where you have a foreign entity, and if you don't register, you don't have to report. Now, apart from that, there are 23 exemptions which apply to exclude what otherwise would be a reporting company from having to report, and those exemptions really relate to heavily regulated entities by the federal government, such as publicly traded companies, various SEC-registered funds or investment advisors, banks, insurance companies, large accounting firms, large commodity trading firms, insurance, really in effect brokers, but they're procurers of insurance. Mm-hmm. And then you have tax-exempt entities and other variants, all of whom are federally regulated, where the information about who is the beneficial owner is disclosed to the federal government. There is one exception which is particularly important for sort of the privately held profit-making type of situation, and that's called a large business organization, which requires that you satisfy three requirements. The first of which is that you generated more than $5 million of gross receipts, and that was reported on your tax return. You have more than 20 full-time employees, and you have a real office in the United States. And if you fall within that particular exemption, then your entity won't have to be reported. So in terms of dealing with this legislation, the first step is to know about the legislation. The second step is to know that you, if you fall within scope, have to report. And that's what we've been talking about so far, is the types of entities that are reporting companies. Now, assuming you are a reporting company, what do you have to do? You have to identify your direct and indirect beneficial owners. And this is a term of art, and there are two tests for making that determination. And once you have identified your beneficial owners, you then will report that information to a unit of the U.S. Treasury Department electronically on a form that you can access on the internet.
Okay.
Now, in terms of the two tests for beneficial owners, and I'm not going to get into the weeds here because it's complicated, there is what we call a substantial control test and a 25% or more ownership test. Under the substantial control test, the beneficial owner doesn't have to have an ownership interest in the entity, but really has to exercise control. And control can be exercised in one of four ways. Or one, if you are a senior officer of the entity, such as the president, the chairman of the board, the chief operating officer, the chief financial officer, the general counsel, or if you don't have a title, if you exercise the same powers as those types of individuals exercise, you are a beneficial owner. So depending and looking at your corporate structure, if you have individuals who fit within those five categories, that individual is a beneficial owner, irrespective of whether he or she owns any of the equity or ownership interests in the entity. The second test is whether you have an individual who can remove or put into place a senior officer or a majority of a board of directors, again, showing exercise of control. The third one is probably the most generic, and that is, do you have a substantial influence over the major decisions of the corporation or LLC? Can you influence the type of activities that it is in, the finances or other important aspects of the company? And then the fourth test is, even if you don't have that power, it's called a catch-all test, can you really behind the scenes make the decisions for the company? So if you are in substantial control, you have to be reported, and the agency which is monitoring all of this, called the Financial Crimes Enforcement Network, something called FINCEN, which, as I said, is within the Treasury Department and deals with money laundering aspects and tracing potential criminal activity in the United States, has an expectation that any particular entity will have at least one substantial control person, but they are looking for as many individuals who are in substantial control. So it is direct control or indirect control, and it is very expansive. And if you have a complex structure, can be a difficult undertaking.
Second Service Foundation is a 501c3 nonprofit that runs on donations from patriotic Americans like you. Your support enables us to continue empowering military veterans and service members as they transition to entrepreneurship. Consider making a donation today to help us make a difference in the lives of those who have served our country.
The second test goes to 25% or more ownership, and under this particular test, the term ownership interest is much more than an equity interest and includes a wide variety of instruments which equate to ownership, which could even include a debt instrument. And the determination made here is whether an individual has an ownership interest, and then, or what is the percentage of that individual's ownership interest. And this can be done on a direct basis or in an indirect basis. So again, if you just have a simple structure with, say, an LLC and one individual, and you own the LLC, you are a beneficial owner, but there are numerous structures involved in commercial activities in the United States where you might join up with a much larger entity, or you may have co-investors, or you may have a joint venture, or you may have had a situation where you're borrowing money and your lender has certain powers. And in those particular structures, you'll have to figure out whether who is in substantial control and who has a 25% or more ownership. So far, what we have talked about is the fact that you first have to figure out if you are under this legislation by figuring out if you're a reporting company, and then you have to determine who are the beneficial owners, which can either be an easy or a complex test. And by the way, the FINCEN has come out with a whole series of helpful assists for you to make these determinations. And before I continue, I'm just going to refer you to where those things can be found. If you go to the internet and you put in the words BOI, say boy, Ohio, Indian, and then put in FINCEN, you will find the website, and it's called the BOI website. And in the BOI website, what FINCEN has done is it lists all the background legislation and regulations and guidance which it has publicized to date. If you wanted to read sort of the basic text of all of this, but also what it has done, it has prepared what's called a small business guide, which is going through what I'm going through now. And it's done in a very user-friendly way because it sort of tees up these questions and puts them in a very user-friendly manner for you to make the determination of whether you're a reporting company, whether you're subject to an exemption, how to apply the substantial control and ownership tests, and so on. And then there's also direction for how you file your report, which we are going to get into. But it's a very useful guide if you are within the space of the Corporate Transparency Act, the Beneficial Owner Information Reporting provisions. So now we have covered what is a reporting company, who is a beneficial owner. You're not subject to any exemptions, you're not out of scope. And so the thing is, when do you have to report and what do you have to report? And here we're going into a series of rules. This thing deals with entities going back all the way. So it's not the fact that entities created in 2024 forward are covered. Entities covered prior through 2024 are covered. So if your entity was formed in 1950, 1960, 1980, 2000, all the things which are within scope are covered. And for those types of entities that are created before 2024, you have until January 1, 2025 to report. So you have nearly a year still to figure all this out and report. For entities created in 2024, just in the calendar year, you will have 90 days to file what's called the initial report. And then for entities formed in 2025 and going forward, you will only have 30 days. So you need to figure out what type of an animal you're dealing with when the thing was formed, or when you registered, the first time you registered to do business if you're a foreign entity, and you then have the various times frames for reporting. Now, this is just the initial report, and as we will be discussing in a few moments, you have to file the initial report, and then if there are changes to the information filed in the initial report, you have to update FINCEN within 30 days, but we're going to go into that in a little more detail. The information which is reportable for entities formed prior to 2024 are certain information about the company itself, its name, its doing business, its address, and its tax ID. And again, I'm being very simplistic here. There's a little more detail to that. And then for individuals, the beneficial owners that you are reporting, there are 4 bits of information and only 4 bits that you have to report. That is the individual's full name, the individual's date of birth, the individual's residential address, and then a unique identifier number, which can come from a passport, a driver's license, or a state ID, assuming it's current, and a picture of that document to reflect, that you're the person who is being reported. Sure. And if you're a non-U.S. person and you don't have any of those 3 items, you have to report your foreign passport. So, for example, if you are in a somewhat in a cross-border situation and you have an individual, a foreign individual, who says, I don't have any of those 4 bits of information, you might find that suspicious, because normally everyone in the world has at least a foreign passport if they're outside the United States. Sure. So it is those bits of information that are reported by the reporting company to the federal government, and it can trace who's who in this system. Now, recognize that you will be giving your personal identifiable information to the reporting company, which is, it doesn't include your social security number, but it has all this confidential information. And if you are in a situation where you might be, you own various companies and you have to provide this information to the reporting company, what you can do, instead of giving your PII, as we call it, is to get what's called a FINCEN identifier number through the internet link, and it talks about FINCEN identifier numbers, and you give your 4 bits of information to FINCEN, it gives you a number, and then you give that number to the reporting company. And this is useful not only to secure your information, but also if you're involved with numerous entities, you don't have to give your PII. The other point, from a reporting company's point of view, it's useful because if you use a FINCEN identifier, the reporting company doesn't have to keep track of those 4 bits of information, and you have the onus of doing that. Though the one point I would mention is to date, if you get a FINCEN identifier number, you have to continually update FINCEN, and if you, for example, got out of the business, you still would have to update FINCEN if any of those 4 bits of information change. But FINCEN should be coming out with some guidance to get you out of the loop if you sort of exit from whatever your professional activity is. So just to step back and say where we are, once you've figured out whether you're reporting the beneficial owners, you get the information which is reported, you file an initial report within the 3 due dates which I mentioned, and then you really need to adopt the system or procedure to keep track of updates. So for example, if you have an LLC or a corporation with, say, any of these senior officers, and these senior officers had FINCEN identifiers, if they were to move, they would have the responsibility of updating FINCEN, and you wouldn't have to update, for example, if for a gent you get a mustache or a beard, or for a gal you change your hair color. It's only if those 4 bits of information change. So now, if there is a change because your president retires, you have to file an updated report within 30 days. Or if someone dies, you have to file an updated report within a certain time frame. And so for those things, you need to adopt procedures, and really agreements with these individuals that they will inform you of these updates, because you need to file this stuff within 30 days. Let me just go through several other things relevant to all of this. If you decide to say, oh, I'm not going to be bothered by this, I don't want to give my personal information, there are both civil and criminal penalties for willful noncompliance or giving wrong information, or for not updating properly. And those penalties apply not only to the reporting company, they apply to the recalcitrant shareholder, and also to the senior officers involved in the particular company. So you really don't want to ignore all of this. In terms of moving forward, what you also need to do is to examine the documents you have, your LLC agreement, your corporate arrangements, your loan documents, and other things. So you put in those documents clauses to enable the reporting company or the counterparty to know the information, the CTA information, which now is required and beforehand was not required. So to put it in other words, if you're forming an LLC today, you not only need to comply with the state law requirements, but you also need to put into the documents clauses to enable the company to get the requisite information for reporting. Another item, if you're forming an entity in 2024 going forward, there's another term we use here called company applicants, and those that is the individual, and it's only up to 2 people who assist in the formation of the company. So if you're forming an entity in 2024 going forward, a law firm or something like that, you would go to the law firm and say, I need an LLC, and they will have an entity formation policy, and they will form the entity, hopefully put in the clauses, and then give you the FINCEN identifier of the individual at the law firm who directed that activity. And assuming the law firm is then using an outside vendor to file the document, it's the outside vendor's employee who also would give his or her FINCEN identifiers, so the company would file its report. If you're using just online software to form the company and doing all this stuff yourself, which is not uncommon, you then become the company applicant, and you again have to give those 4 bits of information or your FINCEN identifiers. So you need to be aware of this. You need to make the various determinations I've gone through. And then in terms of filing, you can either do this thing directly by going to the BOI website and following the directions to provide the information in the initial updated or corrected reports, or you can use an outside vendor, and they will charge you a fee for doing that. And that might be very useful for more complex arrangements because they can keep everything on their computer, and if you have updates or so on and so forth, it's more easier to comply with all of this stuff. The trick really here is several-fold. First, to figure out if you're covered by this, to get the information to do the initial report, and then to provide a procedure for updates and modify your agreements. And then the other thing I want to just mention, from a privacy point of view, the federal government is requiring that the reporting company provides this information to the government. So you shouldn't run afoul of privacy requirements. But if you have non-U.S. shareholders or foreign entities, then you need to explore the foreign privacy laws to see if you're in compliance. And for example, in Switzerland, you will need affirmative consent in certain circumstances to file this information with FINCEN, so you have to know about that. So effectively, what you've got to do with all of this stuff is know that you have a reporting obligation. It's going to be burdensome. You have to follow the updates, which can be found on FINCEN, or have an advisor who can inform you on all of this stuff, and then to see if you can fall with any of the 23 exemptions. And for the small business, basically, you're going to be out of luck generally. It's only if you're in more complex arrangements or have greater revenues that you will fall within what's called the most popular exemption. So this is a whole new thing. It's totally pervasive. It applies to all sorts of commercial activities, and it applies to private wealth planning. So that's just a very quick overview of this, but you just need to be aware of this if you are using an entity where you had to file a piece of paper to commence the organization of the entity. So I think that's sort of a brief overview.
Mr. Granwell, thank you so much for sharing your time and your expertise with our military entrepreneur audience. Here at the Second Service Foundation, we work closely with Holland law offices because they are our sponsor that donates over $200,000 in pro bono legal services every single year to our veteran and spouse entrepreneurs. If you found value in today's episode and you want to continue your journey towards entrepreneurship, be sure to hit like, subscribe to our channel below, and visit secondservicefoundation.org for additional resources and support. Remember, your dreams are within reach, and with the right guidance, you can achieve anything that you set your mind to. Until next time, stay motivated and keep pursuing your military American dream. You've been listening to the Military American Dream, empowering military veterans and service members on their entrepreneurial journey, brought to you by Second Service Foundation. For more information and resources, visit www.secondservicefoundation.org.